And gentlemen, can we just allow the few people about to step in to get seated and comfortable? Afternoon, my name is Ms. Lerato Rinyehelo, and I'd like to welcome you again to the 20th conference. I would like to get on to the order of the day, introducing our next speaker. He's an executive at ENSafrica in the employment department and specializes in extensive aspects of employment law, occupational health and safety law, resolution of labor disputes such as collective bargaining disputes, industrial action, unfair discrimination, but to name a few. He has acted for a number of industry leaders in the automotive, chemical, pharmaceuticals, construction, engineering, distribution, and manufacturing industries, but to name a few. I'm saying but to name a few because his bio is quite healthy. His experience includes providing advice on collective bargaining, strike management, restructuring, outsourcing, tax-related issues, employment equity, so he's good for the money. He has advised on the board of based Black economic empowerment, employment and pension, health and safety, transfer of employees in the mergers and acquisition and outsourcing. He has also conducted investigation, inquiries and inquests in occupational health and safety matters, particularly in the mining industry and the resolution of disputes in the CCMA. Dion has also acted as a judge in the labor court. Ladies and gentlemen, as I've mentioned, our next speaker is Dion. Can we exercise social distancing and clap hands?
Thank you. It's always embarrassing to hear all those things because they're all very old. For those of you who came here to listen to me tell you about the law, let me just completely at the outset set you straight. I'm not going to tell you anything about the law. So this is not going to be helpful to any lawyers who thought that I'm going to provide some insights into how our law on collective bargaining has developed or should develop. What I am going to attempt to do is ask a few questions and generate some discussion around what I think, and I emphasize that it's purely a thought and thoughts of mine about what should be spoken about widely. I think this is it's an important issue, and I'd like to hear your views on it too. So it's collective bargaining in the public sector and where to from here. And effectively, it's really around the current impasse that the public sector finds itself. There was a 3-year wage agreement that was signed 3 years ago, and it was in its 3rd year this year, and the government decided not to fulfill its and comply with its obligations, and so there's an impasse there. And that's really what I want to talk about. But to try and get us started, sorry, do I just press the next year? It's not working. So what you will see there is how I intend to deal with the issues. Where do we come from, the current state of affairs, and where are we going? So where do we come from? So the public sector is quite special when it comes to employee relations in our country because it's got its own set of rules. It used to have very different acts that apply to it. And then from a collective bargaining perspective, it's the only sector that has a bargaining council that applies to all public servants. Okay, so that's the PSCBC. Significantly, prior to 94 and democracy, and then the LRA in 96, and then 97, the PSCBC being formed, public servants didn't have many labor rights. So it was a significant move in 1996 when the LRA came in and the constitutional right to fair labor practices. So it's an important starting point, I suggest to you. prior to 97, before the PSCBC, we did have the Education's Labor Relations Council that dealt with teachers, and the police had their own bargaining forum. So what then happens is that the PSCBC is formed. It's in terms of the Labor Relations Act. There are the sections 35, 36, and 37. And significantly, collective bargaining now becomes part of the institutionalized structure of the public sector. And effectively what happens is that the employer, the state, and then all of the bigger trade unions, and I'm not going to tell you all of the intricacies around how you get to sit at the PSCBC as a trade union, but you need to have a significant amount of members, and there are significant trade unions in the public sector. And so they all sit there and they engage and they negotiate and they collectively bargain. And they have done so since 1997. And it's on all of those issues, matters of mutual interest, significantly social dialogue, which is what I think we should be encouraging, and that's really where I want to get to. And then they also get to resolve disputes. So, as you know, the CCMA resolves disputes in terms of the LRA as the first port of call, and then councils that have the necessary certification. The PSCBC is such council. In terms of its structure, it has the GPSSBC, that is a General Public Sector Bargaining Council, the Public Health one, and then the State Security, where the police are, and the education. So that should give us now an understanding of where we come from. So we've got the structure in place, okay? Any collective agreements concluded by any of those sectoral bargaining councils must be ratified by the PSCBC. So the structure is there, and on my estimation, my assessment, it works. And why does it work? Well, 1.3 million public servants fall within its scope. It's the biggest employer in our country. The last major strike was in 2010. That's 10 years in a sector that has the most employees that we've had a strike. Something must be working. Multi-year wage agreements have been concluded as early as 2001. I suggest there's those benefits, certainty. Essential services, not essential services in terms of the LRA, but citizens that are essential are then guaranteed, certain. And then again, something that I think forms the basis of what I'm trying to do here is I'm suggesting that all of these years of goodwill and building these relationships, importantly trust, and importantly this issue of social dialogue has been established, it's been working, it's been assisting all of us in the background. But then I think we get to some potential problems. So that's where we come from. It's working. It has worked. The structure's in place. The trust levels, I suggest to you, are second to none in any other sector. This employer and its unions trust each other, and they have done so. Just so that you know, 2010 was the last major strike. It lasted for 3 weeks. It was a severe strike. Teachers, nurses, doctors, police, I see nodding of the head, you remember, right? Before that was 2007, also a long strike, approximately 28 days. Before that, 2001. You can see that teething problems, and then we get to a point where success, 10 years of certainty, 10 years of relative IR peace. Okay, so where are we now? We've all seen this, right? Many will describe it, dependent on which side of the fence you sit, as an attack on the workers. Public sector unions launched campaign to challenge government over wage disputes. Government has declared war against public servants. So what are we talking about? There was a 3-year agreement signed for the financial years. This year was the last in the 2 previous years. The government, the state as employer, signed the agreement, complied with it for 2 years. Final year, implementation date was 1 April this year, and the government gave notice through the structures at the PSCBC to their colleagues on the union side that they will not be compliant. There will be no increases this year, in the final year. That's where we are, and that's, I suggest, the problem. Some facts here. South Africa currently spends 1/3 of its annual budget on the salaries of public sector employees and other civil servants. For the fiscal year that started in 2020, state projects that it will spend around 639 billion on salaries for public sector employees and other civil servants. State spending on salaries more than tripled between 2007 and 2019. The main cause of this was the above inflation wage deals that they were striking. On average, public sector employees get paid more than their counterparts. That may sound surprising, but on average, that is true. Found that the real monthly wage of an average public sector employee is 11,600, and on a private sector employee is 7,800. Well, I've spoken to you about the 3-year wage agreement. We now have a situation where we've got a 3-year agreement in place with the final year not having been implemented. The wage agreement makes provision for different salary adjustments on all of the levels that apply in the public sector. And the salary adjustments for those years were implemented, but for the final year. So, when the state as employer gave notice, the necessary processes in terms of the structures of the PSCBC kicked in, the parties got around a table, and they started their dispute resolution procedures. Brought by the PSA and now joined by the COSATU unions to seek for specific performance compliance with the wage agreement. Interestingly, the state has launched what they call a counter application to that application. For the lawyers, that application is a Section 77 PCA application, where they're simply asking for to be complied with specific performance. The counter application, and I said to you I'm not here to talk law, but I'll just give you a brief understanding. The counter application is really based on two legs. One, lack of mandate. That's what's alleged by the state. I don't know how they get to prove that when 2 years of the 3-year agreement was complied with. I don't know. And then a challenge to the constitutionality. Now, I'm sure there's very clever lawyers that are involved in this thing, and I'm sure they're going to have very clever arguments. Our Labour Appeal Court has agreed to sit as a court of first instance in this matter, and will do so on the 2nd of December. But again, I'm not here to talk about the merits or demerits of the legal challenges. I'm here to talk to you and to get your views on a few other things. So very simply, what are the possible outcomes? Well, very simply, the unions win, and the courts say, go and pay what you promised to pay. Or the unions lose, and the increases are just not given at all. Well, I don't know how you succeed if you're the state in proving that this agreement should never have been concluded in the first place if 2 years of it have already been implemented. If it was unconstitutional, it was unconstitutional from day one. And if your chief negotiator didn't have the necessary mandate, he or she didn't have it from day one too. So I don't know. We'll hear what they say. But we can get some learnings from elsewhere. I give you some examples here. Recently at SALGA, a municipality tried to do a similar thing. And they used the affordability argument, which is government's principal argument. And SALGA just said, you go and get the money, go and find the money. You've agreed to this, make good on your agreement. Denel, as you should know, are in trouble. We hear every day from the Zondo Commission on why they're in trouble, but they're in trouble and they couldn't pay wages for many months of this year. The union there went to court. There was an argument around affordability. And again, the court made very short shrift of it and said, you've got an agreement to pay, you must pay. You go and find the money. So I suggest that, very simply, our courts are going to come to a similar conclusion. But I want to rather talk to you about this and get your views on this. Where to from here? Now, I said to you that I think social dialogue is something that we've had, it's been working, and I suggest to you that it's now just been thrown out the window. Where is it that the state and the unions have actually sat down? 2007, 28-day strike, they sat down, they sorted it out. 2010, violence. And everybody's going to court. And this may sound silly for a lawyer to say, I just think that's the wrong way to go. I think social dialogue is critical. I think it's for a democracy such as ours, where we've got the structures in place, I think it's just silly not to use those structures. Now, again, some facts. Our courts don't usually get involved in resolving collective bargaining issues. Our system is built on what we refer to as the power play. It's built on negotiation. It's built on dialogue. It's built on the parties in the arena finding a solution. That's what the court in NUM versus East Rand Gold Mine said. Collective bargaining is the means preferred by the legislature for the maintenance of good labor relations and for the resolution of labor disputes. We've just forgotten that very simple point. What's going to happen here? The LAC rules in one of the parties' favors, it's going to the Constitutional Court. The Constitutional Court will effectively give us an answer that nobody can then challenge. And then what happens? Next year's negotiations are due to start. I can't think that there will be much trust around the table to start if there's a judgment in anybody's favor. Because someone's going to feel like a loser around that table, and someone's not going to trust the other party. I think it's as simple as that. It may be oversimplifying it, but I'd like to hear you on this. So where to from here? I suggest that future negotiations will be significantly more difficult. 10 years of goodwill gone. There will be a successful and unsuccessful party negotiating. Can't see how that is helpful. Trust. And trust, you know, labor lawyers and for all the colleagues from the trade unions and IR backgrounds, you know about how important trust is in a one-on-one relationship, in the employment relationship, employer and employee. It is more important in a collective bargaining scenario. Because when you negotiate and you must bona fide be trying to find solutions. And if you don't trust that the other party is attempting to do that, what chance do you have of finding a solution? And we've had that. This is why I think this is important, and it just appears to me that nobody's talking about it. Why aren't our leaders on both sides saying, get around the table? Solve this problem. I can't see that a court, while they're going to give us an answer, solves the problem. And again, I suggest to you, 10 years of goodwill, is it worth that? Without even trying? I suggest not. Now, maybe I'm stretching this, but again, I'd like to hear your views. I say the potential for the outcome to spill over into the private sector. So let's say the state gets this right. Who's going to respect collective agreements going forward? I suggest employers in the economic times that we find ourselves are going to look to this case if the employer wins and try and use it to their benefit. So in closing, I don't think it's in any party's interest to destroy what they have established over the years. And that's the sad thing. The success of what the public sector has achieved is not as a result of any individual party. It's as a result of the state and the unions working together and participating and developing social dialogue. That's now at risk. I think the election to go to court is premature. They've not exhausted what they can in terms of the structures. And I think proper intent and will, a resolution around a negotiation can be found, and I think that's in the best interest of our country. So that's what I have to tell you. What do you think? Thank you.
You still stand there. Ladies and gentlemen, we're just going to open up for questions. We're just going to ask that we keep the questions brief. There is a platform, the SASLAW app. You can post the questions there and find his contact details if you want to email a more detailed question. I'm sure he'll be prepared and willing to answer. So I'm opening up the floor for a few brief and engaging questions. I think I see Ludwig's hand up.
Yeah, so you sure you don't just approach this whole topic from a false premise, which is that is there trust? Because, and I'm not advocating this, but the statistics you put up and the fact that public services paid is this not a consequence simply over the last 10 years of the employer capitulating every time to the union's demands? And if that is the case, then the trust that your argument is premised on may not in fact be there. What has happened is just for 10 years, the employer has capitulated to a point where they now are in an untenable position. And because of that constant capitulation, and would only in fact be if it's 10-year, if it's three-year periods, it would have only been 3 sets of negotiations that you would have gone through from 2010. You would then be in a position where actually the only relationship the parties know is the employees making a demand and the employer acquiescing to that.
So no, I don't agree. Look, and I haven't given you a complete picture. I mean, we've spoken other agreements that get over the 10-year period that's been concluded. Important ones, things on social justice, things on health benefits, etc. But to come to your point, Ludwig, I think the trust is built in whether or not, when you sit around the table, you get a sense that both parties are attempting to find a solution. That's what I mean by trust. Now, it may be that the state has, I don't know if capitulation is the right word, because that would mean that they wouldn't go through days and days and hours of negotiation. I think that the state has just, their approach and their model has been wrong. And they now find themselves in an untenable situation where you get the facts that I've put up on the board. I disagree. I think the trust is built around that table where it's clear to me that for at least the last 10 years, these parties have managed to find agreement on all things that apply to employees in the public sector. It may be that the government has given in on wages, but the negotiations, I think, suggest that they've been hard, but they've been genuine. So I think trust has certainly been built up with those negotiating parties. Remember, the decision makers don't sit there, right? And I'm not suggesting that there's trust between the decision makers in government and organized labor who sit at the bargaining council. I'm suggesting that it's the people around that table that do find solutions and have done so over a prolonged period where the trust has developed, and it's important for us to keep nurturing and developing that.
If I may be allowed to ask one more question, time allows. The parties rushing to court, as you, if I can put it loosely, do you not think it's an indicator around the fact that the workforce's power and collective bargaining is undermined, not has, but is undermined, and in essence, both parties are saying, well, we don't have space for you here. We do what we want to do. So do you not think that we have finally come to that realization, since parties now have shooted up to court?
Well, I'd like to think that that's the reason that they actually think that they've reached that point. I don't think so. I think that they can try very, very much harder to find a negotiated solution. So, and what do I mean by that? And it's maybe to Ludwig's point, it doesn't mean there must be one of these parties that capitulate. It doesn't have to be a zero-sum game. They could come to another agreement that allows for workers to get some sort of increase. Right now, they've got zero. Okay? So this is now a zero-sum game. And all I'm saying is, where's your ability that you've shown in the past being exercised now? And there's just no evidence of that. And I'm saying that's the problem, because I think you're letting go too easily here.
Well, thank you. That's a very fair answer.
Thank
As
you.
a token of our appreciation, would like to provide you with this gift.